Hi, everyone. My name is Mike Durbin. I'm an investigator within my county, and this program is going to be just a quick overview on what to do if you get called upon to be an expert witness for an arson investigation. So at this point, you've done a very thorough fire investigation, and you've determined that it was intentionally set, and now, after doing this investigation, you are being called to communicate why you came to this conclusion. So the purpose of this is to prepare people who have not testified in court as an expert witness on what to expect and how things will go. So, because you may have conducted a quality investigation, but at this point it doesn't matter if you can't clearly communicate your results. So that's what this quick guide is going to help accomplish. So the first thing, I'm just going to list off some courtroom expectations. So the first thing is you're expected to be prompt. You got to get there on time. People are, like a jury and the judge, are automatically kind of grading you, if you will, by your appearance or by your promptness. If you come in late, they automatically assume this person is probably not a professional, which means they may not even take your testimony seriously. And the next thing is you have to respect the formal setting of court. This means you're going to act in a professional manner and you're going to dress professionally. You're going to wear a suit and tie. This isn't like a weekend thing. This is a very formal, serious thing, testifying in court. So one of the main things that's important is they are judging you on everything that you say, the judge and jury. So make sure you look at them in the eyes. I mean, you want to gauge people are being truthful with you by you look them in the eyes, you look at the judge. It doesn't matter who asks the question. You're always there to speak to the jury directly or the judge. This helps them feel that you're being truthful with them, because it's known that when people are not being truthful, they don't look at you in the eyes. So your main task is you're there to decode the evidence for the jury. It's important to remember that they don't have necessarily the expertise that you have. You can look at data from a fire scene or any other scene, and you can understand, because this is what you do. The people on this jury panel have likely zero experience with fire investigations or what makes a fire do what it does. So it's your job as a fire investigator to walk them through your investigation and explain the relevance of evidence and why it led you to a certain conclusion. When explaining evidence and conclusions to the jury, it is important for the investigator to use simple terms and avoid jargon. If you go up there and you're speaking fire talk like what you do to your colleagues, they've probably already stopped listening to you. Therefore, your testimony is, at this point, kind of useless. I mean, you're there to try to make sense of a pretty technical thing to people that have no idea really about how any of it works. A big important thing is you have to be impartial and only advocate for the evidence and the truth. You're there to tell the truth. You conducted your fire investigation by utilizing a scientific method and known knowledge to come to your conclusions, and you're there to propose and explain precisely that. So, other expectation, just to make sure that you always remain confident, calm, and professional, because that's what you were there to do. You were there to provide your expert testimony. So another thing that's expected of you in the courtroom is when you are questioned by the attorneys or the judge, to always remain respectful and answer the questions truthfully while only saying information pertaining to that particular question. Be prepared to answer questions because they will be asked. So you be prepared. Most importantly, going into my next task is be prepared. Know your case. Know your investigation. Consult with counsel prior to the trial to ensure you both are on the same page on what you're going to present as far as the information. Because at that point, nobody wants any surprises. You want the prosecutor to know exactly what you're going to bring up. And lastly, the better the expert witness prepares will reflect on how successful the testimony will be. If you go in there and wing it, it's going to look like to everybody in that room that you went in there and winged it. You're not going to remember all the details. You're not going to remember any of that. If at the moment you forget a detail or you're asked a question and you can't recall exactly, just remember that you will have your notes with you. That's part of being prepared. And you just have to ask permission to review your notes to refresh your recollection in that case. Fire models. Fire models or any visual aids are simply another tool to help explain to the jury how you came to your conclusions, whether it be photos, large overviews of the scene, or a computer fire model to show basically you take all the information that you obtained, fuels found by the laboratory, temperatures, and it'll plug it all into this fire model, computer fire model, and it could just help. It's not the end all. You're not going to walk in and put on your fire model and walk away. It's just an aid to help present the information that you're trying to describe to them. Again, visual aids will also help if, say, you're trying to describe a specific thing in a scene that made you come to a conclusion, like a burn pattern. Having those large photographs to present to the jury and the judge can help, because they may not understand what a trailer is. They may not understand what you're talking about. However, people understand pictures. It shows a simulation as to how the fire ignited and help explain the findings found around the scene. That's all a fire model really is. Part of courtroom testimony is you're going to present your information when you first go on, and after that, the defense is going to have the opportunity to cross-examine you, where the defense attorney is going to ask questions. And you have to remember their job is to bring out reasonable doubt, because if you remember, to find somebody convicted in a court of law, they have to be found beyond the reasonable doubt. The defense's job is to bring out reasonable doubt. So, how to avoid confrontation with defense attorneys? There's a couple items that I'm going to bring up that'll just kind of help you, because remember, they are doing their job. First thing, just remain cool, calm, and collected the entire time. Remember, you're a professional. Another big one is listen to the question completely prior to answering. It's a big pitfall if you start cutting off the defense attorney, because you may not even know what they're trying to ask you. Let them answer or ask the question completely prior to you talking. Straight from that one is leave a pause after they ask the question. Give the prosecutor a moment to object, because they're going to know whether or not that question is a viable question, and they'll either say object or they'll ask for it to be rephrased. Another one is if you don't understand the question, because sometimes defense attorneys may try to trip you up, ask them to rephrase it or just to repeat the question. And just remember, it is their job to raise reasonable doubt, because you're there giving your testimony on to why you came to your conclusions. They want to question you to show that maybe that isn't the correct conclusion. Remain professional and calm, even if the defense attorney is obviously trying to get a rise out of you. Again, that's their job. If you have somebody get your temper up, the jury's not going to like that, and they're already going to stop listening to you. Answer the questions truthfully and efficiently. And by efficient, I mean only say what you really need to say to answer the question. Don't go on for 20 minutes on a dissertation when all they ask you, even if it's a yes or no question. The biggest thing is remember that you know your investigation. Stick to what you know to be the facts. And for certain things, if they're trying to get you on your opinion, just fall back on that your conclusions are based upon accepted knowledge from documents like the NFPA 921. So you can't go wrong when it comes back from accepted literature. And finally, some last tips for the courtroom is just remember, be prepared and know your case. The more you know and the more you prepare, the easier this task is going to be. You're going to feel good about it when you complete it. Dress professionally. We talked about that before. It means it's huge for the jury and the judge. If you look professional, they always say to act the part. Dressing properly is acting the part. Prepare visual aids, fire models to help explain your investigation, but make sure your prosecutor reviews your exhibits and what you want to do. Again, always be cool, calm, and confident in the courtroom. Remember, you're a professional. Don't get pulled into confrontation with defense attorneys. That's exactly what they want. You be playing their game. Stay cool and collected. Tell the truth. Present the facts. Remember, a well-organized, systematic approach to expert testimony will help you make an effective, informative presentation to the judge and jury. Again, the more you prepare, the more organized, the better your results in court are going to be. Just remember, you've conducted a systematic and thorough fire investigation, and now it's time for you to take an equally important task, which is presenting the information to the jury, the conclusions of your investigation. So I hope this helps you prepare for what to expect when you do testify as an expert witness. I wish you the best of luck. And just remember, just like anything, with repetition, it'll become a normal, and you'll get better at testifying in court. You'll be more comfortable with it, and you'll grow as an investigator as a result. Thank you very much. Again, I wish you the best of luck on your upcoming testimony. Thank you.